Good morning, all my members here. And in this new series which we have launched today, I, on behalf of the Institute, welcome all our members who have joined today for this webinar. And I'm sure many more members will join by the time we start. Friends, fortunately, today we are joined by one of our members who, in fact, I feel needs no introduction, CS Dr. Kundla Bhaskar Mohanji. He is a very well-known company secretary to begin with. And he is one of those company secretaries who have made our profession proud. And by members like Sir, we feel that the stature of our profession itself has gone up. Sir, I remember I used to appear before Sir when we used to call him my lord. Before Jaipur bench, many times I appeared before Bhaskar Mohan Sir. But thereafter, because of some personal reasons, then his lordship had to go back to hometown, Hyderabad, and leave the judicial service. But as the company secretary, I would say that it's an honor for all of us to have Mr. Bhaskar Kundla Bhaskar Mohan with us today. And Sir is synonym to arbitration and ADR. That's how I see. And he's one of our pillars for all our initiatives on ADR. Friends, as you would have seen, that your institute and your council, the one which you have elected, and in fact the recently elected council, has been taking innumerable number of initiatives to raise the capacity of our members, because we feel unless we ensure that the capacity is honed up on a regular basis, on day-to-day basis, and that goes into our blood. And that's what before this call, I had a 30 seconds to 1 minute interaction with our learned faculty today with Mohan Sir. And I said, Sir, thank you for being here. And he said, I said, Sir, you are a legend. I really, really pour from my heart. I really respect you a lot. And Sir said, yeah, I'm a learner. And I said, Sir, initially 10-15 minutes, I'll share about initiatives of the Institute and give a very brief background about arbitration, because I also deal with arbitration and we are learning from Sir. And the answer I got was, Sir said, Mr. Chawla, I am a learner. And that's the beauty of a legend. We all have to have this attitude of being a learner. You know, there are many times we mention in our interviews that it is up to us whether to choose Saraswati or Lakshmi. In the Saraswati, and then continue to choose Saraswati, Lakshmi will automatically follow. And that's what we all need to inculcate. And in this background, your institute has taken so many initiatives. And this initiative is one of these initiatives which are present, young, dynamic, always available for our profession, Mr. Manish Gupta, and our super legend and super senior Mr. B. Narasimhan, our vice president, thought to spend a lot of time in developing the capacity of our members in ADR. Now, friends, this alternate dispute resolution is not alien. This is not a subject which is, many members feel ADR, arbitration, mediation. No, this we have not done. This we have not studied. This we have not dealt with. It's a myth. Trust me. Because we have in our curriculum studied ADR, we have in our curriculum studied arbitration, we have in our curriculum studied mediation. In fact, in our own Mother Companies Act, which is the mother law for all of us, there is a mechanism by which we all can become mediators. The regional director does that empowerment. You fill the form. There is a criteria. I don't know how many of us are aware. The provisions are there. What is important for us is to ensure that we grab on to these opportunities which comes our way. Section 442. I'll just mention the section and then leave for you to read this provision later. Many years back, me and my mentor Satvinderji got impaneled there, and the regional director of every region every year creates a list of the professionals, CA, CS, CWA, who are impaneled as a mediator. And one must read section 442 read with rules. Now, this is one. And this is not alien. So let me start, instead of requesting our faculty member, who is the company secretary and a trained mediator, arbitrator, and a judge as well, and a former judge as well, to start enlightening us with the basics of arbitration. Because the difficulty is that members I have seen, and even students, somehow feel that, this is a subject which we haven't handled ever. We are doing Companies Act. We know our own subject. Now, fortunately, with your own effort and with the hard work put by your council and the institute, we have been able to make a mark in IBC, in valuation. So apart from Companies Act, now we are known as insolvency professionals. We are known for appearing in NCLT. Before his lordship, at that time, Mohan sir, at that time also, many company secretaries used to appear. And sir has always given that due motivation and regard to the company secretaries, because we are extraordinary. I remember my interaction with former S.M.M. Kumar, and he used to tell us that company secretaries are masters when it comes to law and interpretation. Nobody can beat us. But when it comes to when it comes to oratory skills, when it comes to presentation in court, 5 years back we were lacking, but now we are not. Many company secretaries are beating. In fact, the other day I met a company secretary, young fellow from Chennai. Is the preferred over lawyers to appear before tribunals, NCLT, NCLAT. Why? Because of our domain expertise. What we need to do is continue honing up our skills of appearing, art of advocacy, learning, and at the same time pick up these new areas of ADR, because ADR gives us more time. The basic difference between dispute resolution by a court mechanism or by ADR, how I see, is time. Here, the judges are not in hurry. In court, you are given 1 minute. In Supreme Court, we are given, at many times, you are given 1 minute. The file is thrown out if you are not able to make out your point in 1 minute. And that's how the difference here is that the mechanism is established. Everybody is recognized. The judges have ample time. Although now there is a statutory time frame for former judge Justice A.K. Sikri very recently, few days back, a month back. And the 1 year had elapsed, and I on my own mentioned that, my lord, 1 year time has gone up, and I think my friend will agree. My lord may give us the reasons and the order may be passed so that tomorrow it doesn't come on the bench, on the arbitral tribunal, that the matter has not been disposed of in terms of the 1 year statutory time frame. So what I'm trying to explain is that Vidya Vichare te Paropkare. This is a line from the Gurbani, which I always quote in all my sessions. Why? Because unless we consider Vidya to be, we need to disseminate this knowledge. We need to learn, unlearn, relearn. And therefore, for you to join this webinar on a Saturday in this series in large number will motivate us to have many more of these programs and these sessions. Friends, in ADR, the subject is wide. There is a difference between arbitration, mediation, conciliation, and our learned faculty will certainly deal with this aspect. Certainly today we thought to start with the basics of arbitration. How I feel arbitration. If I tell you in 5 points, which I'm certainly sure Mohan sir will articulate in detail. In 5 points, if I have to in 1 minute tell you what are the basics of the arbitration. 1, arbitration is governed by an agreement. There has to be in writing an agreement between the parties. Only then the dispute can be resolved through arbitration. Must be in writing. Orally can't be. It can be through an email. It can be through a separate agreement. It can be through a clause in the main arbitration agreement. 2, the important point is that few disputes are arbitrable, few are not. Not every dispute is arbitrable. And you can't choose. We can't decide that this clause, yes, in the agreement, we must include what disputes are arbitrable. But by way of law enunciated already, there are few disputes which are not arbitrable, which is insolvency is not arbitrable. Although there is interplay of IBC provisions and arbitration as well, which we can separately deal with in the question we have already received. So first is agreement. Second is arbitrability. Like marital disputes is not arbitrable. Like intra-companies disputes is not arbitrable. I remember I appeared before Mohan sir in a matter before Jaipur bench. Went on for 3-4 hearings. And I really appreciate Mohan sir, at that time, he used to give so much indulgence to juniors and youngsters, young company secretaries, wherein I was making an argument with regard to Section 8. We had filed a Section 8 of Arbitration Conciliation Act. We were saying that this dispute has to be decided only by arbitral tribunal. The other side had filed an operational mismanagement petition, which sir will articulate in detail whether a dispute is to be decided in an operational mismanagement petition, or if there is an agreement between the parties with regard to arbitration, or it will have to go to the arbitrator. So arbitrability is to be decided. Third and most important, which is the pillar of arbitration, is party autonomy. You decide. The parties decide who will be the judge. The parties decide who will be the arbitrator, who will arbitrate the dispute. And that's how we say that you have to decide your own judge. Both parties can decide one, and those two can decide the third arbitrator. Or if there is a sole arbitrator provision, it can be even sole arbitrator decided. Unilateral arbitration is not permissible now. Perkins' judgment had come. Not that earlier PSC used to say that a public sector undertakings officer will become the arbitrator. It's not permissible now. Mohan sir will articulate and will deliberate on this in detail. Fourth and most important is SPV. SPV, seat, place, venue. You decide your own seat. You decide your governing law. You decide the place where you want the arbitration to take place. You decide the procedural aspects of the arbitration. That's how it is called party autonomy. And the fifth and the most important pillar, and the last in my view, is the judicial intervention, which has been mandated to be minimal. The judges and the courts don't intervene till the time it is required. The finding given by arbitrator these days is tough to object to. There's a provision of Section 34 which deals with objection. Yes, but the grounds for objection are very limited. Therefore, whatever battle you want to fight, you'll have to fight it before the arbitrator. And my dear friends, let me tell you, don't feel that we don't deal with this subject. Many of our company secretaries, so these five were the basic of the arbitration, but many of our company secretaries are already acting as arbitrators. How? There is a provision in the NSE and BSE bylaws, where company secretaries like you and me can become the arbitrator. I can share the detail of those circulars, and you must apply to become the arbitrator for the disputes raised by the shareholders with the NSE, National Stock Exchange, BSE, Bombay Stock Exchange. They have a mechanism where you and I can become arbitrator. There is a criteria. You fill in the form. They'll see at your qualification, at your experience, and then you become the arbitrator. One is becoming the arbitrator. Another is becoming a counsel. And you can argue very well before the arbitral tribunal. You can assist the bench as an expert, being a valuer, being an expert company secretary. You can file your expert witness report also if required before the arbitral tribunal proceedings. Similarly, there is one area which may not be known to many of us. I did a seminar last year, friends. There is a circular of SEBI which has come last year, dated 30th of May 2022. Must note this. 30th of May 2022. SEBI came out with a circular which is circular dated 30th May, number 2022-76. Amazing circular, I would say. Gives an extraordinary amount of opportunity for company secretaries to become dispute resolution expert through ADR. A mechanism was initiated by SEBI, wherein initially the disputes which were decided by this ADR mechanism were very few. But by this circular, it was expanded. Now, most of the disputes, like transfer transmission dispute, has to be decided by arbitration. Sir, it would be very interesting for everybody to know that recently I argued a matter for 4 hours myself before ROC Delhi. In that case, the shareholder, one of the shareholders who purchased some shares, entered into a share purchase agreement, filed a complaint before ROC that the duplicate share certificates are not being issued to him. I was representing the company. I said, sorry, the petition is not maintainable. This dispute is pertaining to issuance of duplicate share certificate. Any dispute pertaining to issuance of duplicate share certificate for transfer transmission or any of such shares, any of such rights pertaining to the shareholding has to be raised before SEBI in case of a listed company. This was a listed company. I got a 15-page detailed reasoned order, which the other side has challenged in writ petition now. And in that case, coincidentally, when we did more research, we realized, and from the facts of the case, that the company, that the shareholder had already filed a complaint before SEBI, which they had not disclosed. And SEBI had already rejected their complaint on the grounds that it was not, on merits, it was not maintainable. On the merits, they had no ground. On two grounds, we got a favorable judgment in detail. So therefore, what is important for us to know what is the available option with us? The available option for us is to become an arbitrator, to tell our company, if somebody takes you to NCLT, that's another right of transfer transmission is refused, section 58, 59 of Companies Act 2013. Therefore, this is another area. So don't feel that this arbitration is alien. It is already there in 442 of Companies Act. It is already there in NSE, BSE provisions. It is already there in this circular which I have mentioned. And most importantly, it is already there in our curriculum which we have studied. So friends, this is the brief background I can share about the kind of available opportunities with us. Considering this, your own institute has thought it appropriate to come out with ADR centers. In institutional mechanism of arbitration and the ad hoc mechanism of arbitration, what is the difference between these two, and how can our members go to DIAC or even go to other arbitral institutions? And you would be happy to know that Sir hails from Hyderabad, where we have our ADR center. The first ADR center was formed there, and now your institute has also approved another ADR center in Bangalore. We will be soon coming up in ADR centers at different places in NCR, in Noida also, because your institute would now be having a CCGRT, like earlier we had CCGRT only in Mumbai, which was Navi Mumbai. Soon you will have it here in Manesar also. A huge campus is being built by your own institute for developing the capacity of our members for having residential programs. Like in Hyderabad, Sir's our faculty's own city. And Sir is a permanent faculty of all our initiatives in our CCGRT Hyderabad. It was Center of Excellence earlier. We have now renamed it. In fact, not only this, extreme contribution, extraordinary amount of contribution. This is huge amount of work which Mohan Sir contributed. This is called Handbook on Arbitration, a practical guide for professionals. This is published by your own institute and by the center under the aegis of Center of Excellence Hyderabad, which is now CCGRT. Because in one of the council's meeting, I thought appropriate and gave this suggestion, and the council somehow found merit in my suggestion that why are we having different names, Center of Excellence in Hyderabad, CCGRT in Mumbai, and something else in Delhi, in Manesar. Why can't we uniform it? And that's how we recently decided that all such Center of Excellences would be renamed, and it will be now named as CCGRT Hyderabad, CCGRT Mumbai, CCGRT Manesar. And now the next one, which is being inaugurated very soon, it will be CCGRT Kolkata. The building is made. I recently went. Wonderful campus they have made. So we'll have 4 such research centers. We need your help in one thing, that whatever we do, we need your guidance, members. We need your encouragement, because we need your feedback. We need your participation. Unless you participate, like in today on a Saturday morning, if you are able to participate, only then we will be encouraged to take such initiatives. And this is one of such initiatives where our President, Mr. Gupta, thought it appropriate to initiate such webinar series, which is having one PCH as well. And this book, friends, I've been informed by Rakesh, is available on the e-cart also, and you can take it from the chapter offices also. Just get this book. After this session today, just get the book, start reading it. Automatically, you will find more interest in this subject. Go to NSE website, look at that circular, go to Companies Act 442, start graduating. The next buzzword for our members they may be in job, they may be in practice. I have seen a very senior company secretary in a huge arbitration before Justice M.R. Shah. We are involved. a company secretary is briefing a designated senior advocate, he's navigating the way. A company secretary of a company, he's the one who is being cross-examined in the cross-examination as a witness. So that's the kind of contribution our members can give. I think I have given the initial background about this subject, and I have also mentioned that we are fortunately joined by none other than the founder of all our initiatives in ADR. And, Shri Dr. Pundla Bhaskar Mohan is always available for our institute. He feels that he is a company secretary first, then an advocate, then a judge, and now again going back and giving back to his own alma mater is huge. I mean, that's the thing which we need to learn from seniors like Sir. Sir is a former judicial member and head of the Department of Jaipur bench of NCLT, as I mentioned. Mohan Sir is presently practicing as an advocate of High Court of State of Telangana and also acting as arbitrator and conciliator. I have met Sir many times and he is always available for our members. He is MCOM, FCS, LLM, PhD in law. And, I am gradually learning from Sir, that's the only qualification which I need to add. Doctorate which Sir has done, and I certainly will seek guidance from Sir also as to how can we also learn, and is a PhD in law as well. So Sir was enrolled as an advocate on 26th of September 1986 and was attached to the office of late Shri V. Rajagopal Reddy, the senior advocate there. And from then, Sir was having independent practice in various streams. He is also associated with the International Center of ADR as faculty member, with the ASCI, ESCI, CIRE. And that's how I said that the word synonym is absolutely correct. He's everywhere. Wherever there is ADR, Mohan Sir would be there. And I would say that whenever, friends, you need any guidance, Mohan Sir would always be available. We are always available. I am personally always available. Institute is always available. Banu Madam, under whose guidance we are taking this initiative. Our own member, Company Secretary Banu Dandona Ma'am, Rakesh Ji, who did a great job by arranging the logistics, by framing the program. And, we are thankful to them for their support. Mohan Sir, over to you to enlighten our members. We have already received some questions, and at the end, we will make it interactive. I'll ask you some questions at the end. Now for about 1.5 hours, 1 hour, 15 minutes. Please enlighten our members about the basics of arbitration and inculcate this subject and raise their confidence as well. Over to you, Mohan Sir.
Yeah. Thank you very much, Chawla Sir, dear CS and PS Chawla Ji. And at the very outset, I convey my deep gratitude for having invited me to share very little of my knowledge with our fellow members. I am grateful to the admin, the Honorable President and Vice President, and you, Banu Madam, and all for this invitation. This type of programs would further, in fact, refresh the knowledge. And I had to do a little work again to upgrade, and that would be useful in my profession as advocate. So that is the advantage I get. So I must thank you for giving this opportunity. I had to argue few matters on 37 before High Court next week. So by going through again and again, that would be of great help. So thank you very much. And a very good morning, my dear fellow company secretaries. And we should be very proud being a member of Institute of Company Secretaries. I was passed out in December 1989. By the time I picked up 5 years standing as a lawyer, and I have decided to continue my practice on corporate laws as well as arbitration law. As back as 1986, I was introduced to the legal profession. In fact, I started with practice of company law in High Court, Company Court, and also the arbitration law. That is how things went simultaneously. So in the initial stages, I was wondering, I was arguing some matters against certain advocates, then the learned judges, And after the court time, the same advocates sometimes used to be acting as arbitrators and I would be appearing, and or else some other advocates as opposite side appearing before retired High Court judges. So I had to make out the thin layer between the arbitration and courtcraft. Because the courtcraft, the training is different. The arbitral tribunal, the procedures and the training are totally different. So that is where the distinction comes. We have more freedom, rather absolute freedom, as Mr. Chawlaji very rightly pointed out, in arbitration. Exactly what this arbitration is, I think slowly we will try to, already enough introduction has been given by Chawlaji. I think slowly we can go into the depth of the subject matter. So what exactly is arbitration? How is it permitted by law? Like, for example, the meaning of arbitration is taken as third-party adjudication. So a fundamental question, if it is third-party adjudication, then how the third party is permitted to adjudicate? Adjudication is the prerogative of the courts of law. So we have got a constitution. The constitution dictated that for justice, you have to go to courts of law. And the courts will give decisions. So that is called adjudication. Adjudication means deciding on the rights and liabilities of the parties. In that event, a court of law, I approach saying, my land is occupied illegally by so and so, it is my land, and I show the documents. And the court declares it's my land and then directs the opposite party to get vacated. So this is adjudication. There is a person whose parent passed away, left behind properties. There are 5 sharers. And then for mutation purpose, these properties have to be put on so and so. The question is now no will was available. How to divide? There is Indian Succession Act for that. Hindu Succession Act for that. Depends upon the person's religion, etc. In the same way, the hierarchy of legal heirship, distribution of property, given in personal laws. Indian Succession Act is there for that purpose. For Hindus, Hindu Succession Act. But who would adjudicate and give the partition? The court of law. So the court of law adjudicates as to who are the persons having right of sharing, number one. Second, what type of sharing? Third, what to be shared, what not to be shared. That is where the preliminary decree and then final decree come into picture. This is the courtcraft. For everything, there is a hierarchy, there is a procedure, and the adjudication process is dictated under various legislations. If that is so, how law permits a third party who is not a judge to become a judge? One has to be first a qualified LLB, one has to be a lawyer, then subsequently he would be undergoing a test, etc., and then he would become a judge, training then. Without all this, can a third person who is trusted upon by the parties be entrusted with this particular judicial process. That is the most important thing. So the answer is, prima facie, you go to the answer fundamentally. Unless there is a legislation permitting third persons to adjudicate, act as de facto judges. De jure judges means under statute they are the judges, like the civil court, criminal court, high court, supreme court, tribunals. De facto judges means the persons appointed by the parties privately, discharging judicial functions. So they are called de facto judges. If that is the case, how these de facto judges could be permitted under what law? So we had to first search for that. And without LLB, a person who is a company secretary, whether he can act as a adjudicator. Now the adjudicator is referred to as the arbitrator. That means arbitration proceedings constitute the proceedings of a private court. Arbitrator is a private judge, privatization. The arbitrator's decision called award is a private judgment. Proceedings are private court judgment, private court proceedings. Taking this analogy, my dear friends, which law basically permitted this? I draw your attention because this is not a direct appearance. Probably there can't be two-way questions and answers and interaction. This may not be an interactive session. So at the moment on the screen, I am only seeing my face, but none others. So I hope all others are listening. And then later on, questions and answer session, let us see. That also would be one way. Seeing the questions on the screen, I will have to answer. So taking this analogy, not being an interactive session, I myself will have to answer this question. That is, which law permits arbitration? As back as 1872, the Indian Contract Act has been incorporated. As back as 1870, Indian Contract Act. And Indian Contract Act says, under section 28, restraint of legal proceedings are void. That means, if I say I will refer my dispute to a private person, not go to court, close the doors of the court, then they are void. In that event, how Arbitration and Conciliation Act has come. Arbitration and Conciliation Act has not brought any rider or amendment to Indian Contract Act. Indian Contract Act prevails. Arbitrator is a creature of agreement. A judge is an appointee under the statute. Civil Court, Criminal Court, NCLT, NCLAT, CAT, for example, Supreme Court, High Court, they are appointees under the statutes and the Constitution. High Court and Supreme Court judges are constitutional functionaries. If that is the case, by agreement, a judge can be appointed. But Indian Contract Act says, section 28, restraint of legal proceedings, void. So fundamentally, you will have to understand where we find the way out. The same section 28, Indian Contract Act, provides a way out by saying that there is an exception. Same section 28. What is that exception? Exception is that arbitration is permissible. So that is the genesis of arbitration. That is the genesis of arbitration. A third party adjudication, referring a dispute in a court of law or people opting to resolve their dispute to arbitration, permissible under the explanation given as an exception to this rule, to this law, section 28, that it does not constitute restraint of legal proceedings. So, my dear friends, we have got clearance for arbitration in the Indian Contract Act 1872. So, as back as 18, in that particular time, at that particular time, it was considered that we can go for a third party adjudication, and the power of the courts to be shifted to a third person chosen by the parties. Parties would be given that particular option. Friends, I share a more interesting issue pertaining to arbitration, that as back as 1781, where I think in India at that point of time, slowly the Indian national movement was gathering momentum. The great men, great leaders were not yet born at the time. And that was the end of almost 18th century. The British Crown issued regulations through East India Company in 1781, saying that exclusively the certain matters in courts could be diverted to third party adjudication, call them as arbitration. Imagine. Then very surprising thing, 6 years later, it was found to be working well. Further regulations were issued in 1787, stating if the subject matter value does not exceed 200 rupees. 200 rupees is not a small amount, was not a small amount during 1787, 200 rupees. The below 200 matters could be referred to arbitration. With the consent of parties, the courts can, it is not direct. It is not direct. Matters pending, some matters could be referred to arbitration. Then in 1833, 19th century, Indian independence movement gathered momentum, 1857 mutiny, and then several leaders were born by the time, and a lot of choirs, jails were filled with the nationalist leaders. At that time, the governor of Bombay issued regulations recognizing arbitration. Then, friends, the Civil Procedure Act 1857 was incorporated, was brought into force, permitting arbitration as part and parcel of arbitration, in fact, a civil procedure code, followed by a revision in 1882. Then an exclusive arbitration act was passed in 1940, prior to independence, and that was improvised. And 1996, Arbitration and Conciliation Act was brought into force, wherein conciliation was also provided as a dispute resolution mechanism. And under Section 30 of the Arbitration and Conciliation Act, arbitrator can use the mechanism of mediation and conciliation and pass a consent award so that there won't be any further escalation of the disputes over higher courts. So that is the beauty of the Arbitration Conciliation Act 1996, dear friends. And then the enactment makes it clear about how to conduct arbitration, what to do, what not do, what can be referred to arbitration, what cannot be referred to arbitration, and then how the arbitration first to be surfaced. Like Companies Act, telling us about, that's our Bible, either as a lawyer or as a company secretary, the Bible for corporate practice is company law. But as a corporate lawyer, we can't be restricted to only company law. We have to go to all corporate laws. And the base for all our practice in corporate laws and arbitration law is, the base is Indian Contract Act. If we don't have grip over the Indian Contract Act, everything goes waste. Articles and memorandum bound by the Indian contractual relationship. Arbitration surfaces only through an agreement. Even court appoints, subject to only agreement the court will appoint. So friends, agreement is a must. Before I continue our discussion on arbitration, like what is arbitration, I have told you. How we go about, how it could be surfaced, how it could be taken up, what is the stroll further, and how it could be concluded. The effect of arbitral awards, all these things. I would like to tell you, what is exactly ADR? That is more important. ADR means alternative dispute resolution. What do you mean by that? For dispute resolution, we have got a courtcraft. We have got a constitution. Constitution provides for dispute resolution through courts, and there is civil administration of justice, there is criminal administration of justice. And there are civil courts, there are criminal courts and tribunals, like NCLT, for example, NCLAT, SAT, and then FEMA Tribunal, Service Tribunal, Central Administrative Tribunal, Industrial Tribunals. Now, this particular regular courtcraft obviously causes delays. And then inflow is high, number of judges are less. The whole of India with 140 crores of population is having, according to my study, maybe we have less than 50,000 judges only in the entire country. Supreme Court, High Court, civil courts, criminal courts, tribunals, all together, we have only less than 50,000 judges. Several vacancies are unfilled. So, the people of India still believe in courts or adjudicative system, either courts or alternative dispute resolution, but rarely they take law into their hands. A tenant forcibly continuing in the owner's house, owner is a 75-year-old man, and then he's not vacating, he's not paying rent. Well, the 70-year-old man cannot go to a henchman, Gunda, and ask him to throw him out. Agreement is over. And He's not paying rent also. He cannot do that. And mostly nobody does it. They go to court, file a suit for eviction, and make a request for direction, a mandatory injunction to deposit the money, rent in the court. If it is a mandatory injunction and the tenant does not deposit, he will go to jail. He can be punished. And there is a process of recovery. It may take time, no doubt. Because of our population, and as I told you, less than 50,000 judges we have, it will take time. But the court can take urgent motion, court can grant urgent relief, court can direct him. No court will say, without paying rent, you enjoy. Take it for granted. Court will say, all right, your stay we will decide. First you keep paying the rent, give arrears. Even his salary can be attached. So that at the threshold itself, money can be attached and then paid off. The court can give a direction. Alternatively, punishment. So taking this analogy, dear friends, what we understand, people don't take law into their hands. Mostly. They believe, have faith in the end. India is a very strengthened and strong republic. In spite of all the delays, all the problems, the courts function and then do render justice. This is what we have to realize as professionals. So taking this analogy, we have got a regular court system which is functioning, but for a more quick relief and cost effectiveness, and further to cut down further appellate hierarchy. If eviction is ordered by a trial court, it can be appealed to higher courts. Then it will end up in Supreme Court. Maybe rent being paid, but the property will come to the hands of the person. Whether it will be in his lifetime or it will go to his legal heirs, God knows. These are all the things, certain issues which we have to bear with. An alternative is called ADR, Alternative Dispute Resolution, which was in a piece rate manner introduced in India. The first and foremost, that means alternative to the, not substitute, my dear friends, not substitute, only alternative. There are A and B. You disputant choose A or B. Both the disputants agree, go to B. If they don't agree, go to A. That is courts. If both say, all right, we will see the hierarchy in alternative dispute resolution, go to B. That is, B is alternative dispute resolution. A is regular court system. At this point of view, under B, what are the different modes of alternative dispute resolution? As I told you, in a piece rate manner, in India, the ADR mechanism, that is the alternative dispute resolution mechanism, had been introduced phase by phase. In 5 minutes, I will complete the ADR mechanism, then concentrate on exclusively arbitration. Because you must also understand this ADR and arbitration. ADR is alternative to the regular court craft. Under ADR, there are different methods. What are the different methods recognized ultimately? What are the wings of modes of ADR? This is what we are going to see now. Friends, the first and foremost introduced for a long time as an ADR method is arbitration. Because the story starts in 1781 and 1996, further refined, reformed, and the 1996 Arbitration Conciliation Act now has come to stay with various amendments brought in 2015 and subsequently 20 also. And a lot of arbitration jurisprudence has been developed in India by the High Courts and Supreme Court. Of course, a new wave will be that would be decided by the High Courts or automatically, normally subject to Supreme Court's jurisdiction. And Supreme Court has developed a very wider law. 136 SLP, because there is no direct appeal provision like NCLAT. Against NCLAT, there is an appeal, which is a right. But against High Court on Section 37, appeal under Arbitration Act, only SLP, 136, article. Then Supreme Court has made out laws, appropriate decisions on arbitration under Article 141, read with 142. Whatever is made by Supreme Court is a law binding on the country to get complete justice. So Supreme Court tried to look at making out a complete justice and then develop jurisprudence on proper lines for this arbitration. I can say there are several issues still under consideration, developing. Why? Because the Supreme Court is considering various permutations and combinations. And to a greater extent, the law is now settled, which may be subject to further change by the decisions and interpretation, as well as amendments that would be brought to the Arbitration and Conciliation Act. As on today, what is the arbitration law we are going to see, my dear friends? In this regard, as one of the first and foremost method of ADR, arbitration comes because of 1781 introduction. Now, what is the second method? The second method was taken as, in fact, Lok Adalats. Lok Adalats were introduced for settlement of disputes in 1987 by Legal Services, introducing Legal Services Authority Act. Legal Services Authority Act has made out a wonderful system called Lok Adalat, but of course, headed by judicial officers, but making out permanent Lok Adalats, regular Lok Adalats, at national level, mega Lok Adalats. And now the regular Lok Adalats are attached to all courts, starting from Supreme Court to the lowest court in India. And they are also now spread to the tribunals. In future, NCLT, NCLAT also may have Lok Adalats. Possible. Because a lot of settlements taking place in NCLAT, NCLT. We all know. Now I am back to practice in high courts as well as NCLAT, NCLT. So this is part and parcel of our practice. So, my dear friends, Lok Adalat system, especially regular Lok Adalats and the mega Lok Adalats, apart from the permanent Lok Adalats for public utility services, playing a very pivotal role and hundreds and thousands of cases have been disposed of. Because as per the CJI's findings last time, more than about 6 crore cases are pending in this country. In a year, as Lok Adalats are constituted all over India, several thousands of cases could be decided. That is the advantage. And then whether they are pending or whether they are directly to be taken up through PLC, pre-litigation cases. Pre-litigation cases. So this is the second ADR, because arbitration top. Second ADR, 1987. Then 1996. The Arbitration and Conciliation Act was brought into force. And according to the Arbitration and Conciliation Act 1996, conciliation has been made out. Third ADR. Conciliation has been made out as one of the dispute resolution, ADR, alternative dispute resolution mechanism. What is conciliation? How to do conciliation? What is conciliation? And then how the conciliator has to act upon, and then how commercial disputes could be resolved, what is usage of trade, and how to conclude it, how to make out an agreement. All these things are made out under section 61 to 81 of the Arbitration and Conciliation Act. The Act tells you, read it thoroughly, it will tell you. Then in the Act, it was pointed out, if a conciliation settlement agreement is signed on proper stamp paper, of course, by both the parties, and underneath authenticated by the conciliator, as it was done under his conciliation, it will become a decree of court without court interference. In fact, Lok Adalats still involved with judges, but arbitration and conciliation, absolutely there is no court interference. Arbitration award need not be stamped now by courts. Conciliation settlement agreement as on today need not be stamped by courts. You need not approach courts. Parties and conciliators sign. From that moment, it is a piece of decree. And mostly settlement will be over by that time. Alternatively, anything remains, it can be taken for execution proceedings directly without again going for a trial. Trial is not necessary. This is the advantage of conciliation. So, historically, 1781, arbitration number 1, 1987, ADR, Lok Adalat with judges. 1996, conciliation, Arbitration and Conciliation Act. 3 different systems we have seen. Now we come to 2022, my dear friends. 2022, where Section 89 CPC was amended. And Section 89 CPC was amended in order to provide 5 elements of ADR. Yeah? 5 elements of ADR. What are they? Arbitration, conciliation, then mediation, judicial settlement to Lok Adalats, out-of-court settlements. Actually, Section 89 CPC says out-of-court settlement also is permissible, which is called, the parties can come and say, sir, we settled, please pass a decree. That will be an order of the court of law. Arbitration, I told you. Lok Adalat, I told you. Conciliation, I told you. Then parties settling it out of the court is one aspect. Fourth one. Then last and final is mediation. In this, mediation, conciliation, arbitration involve third parties in ADR. And then out of court settlement, Lok Adalat, judicial settlement, Lok Adalat, involve judges only. So 5 elements. So what are the 5 wings of ADR arbitration? Including involving judges, Lok Adalat, judicial settlement. Then, without involvement of judiciary, with third parties. Who are third parties? You and I. Any person of 18 years completed, a major. Through him, he is third party. Parties have confidence, go ahead. Then, arbitration, mediation, conciliation. Total 5 elements form the ADR. What is mediation? In mediation, there is now mediation centers established all over India, from Supreme Court to lowest courts, called court-annexed mediation centers. Everywhere they are available today. Government spent crores of rupees on it with the indulgence of judiciary. And mediation centers are headed by judicial officers. But mediators are third parties. And who are the mediators? The civil rules of practice amended. Recognition has been given to professionals. Who are they? Of course, advocates, company secretaries, chartered accountants, cost accountants, doctors, psychologists, psychiatrists, engineers, chartered engineers, certified accountants. Why so many people? Depends upon the subject matter. Irrigation project, engineers are required. Construction agreement, engineers are required. Commercial matter, a company secretary would be useful. Settlement of accounts, chartered accountant. Partition, lawyers. Lineage, legal heirship. Intestate succession. And a settlement with multiple claims. Sometimes a situation arises, a person's leaving behind huge amount of properties, running into lakhs of crores, and parents die. So how the matter could go on? And it differs from religion to religion. Like Christian marriages, Hindu marriages, Mohammedan marriages, inter-religious marriages, may not be intercaste, but inter-religious marriages. Even intra-religious, there could be some today problems. Today, women have equal share with men. So we had to identify as to whether this is a matter could be sent to mediation, conciliation, or arbitration. Which matter has to be referred to which ADR mechanism. Right? We are at the moment, webinar is on arbitration. But why I have taken time to give you this analogy for the reason that tomorrow mediation comes into your mind, ADR mechanism comes into your mind, arbitration comes into your mind. You should not get confused. So to finally put in through, there is a legal system, courtcraft, running regularly. If I say I am a disputant, I have got huge amounts of property, I don't want to take up ADR, I will continue with my regular courtcraft. Go. Welcome. May God bless you. Spend some time in the civil court. Basically, you have to go to civil courts, except it depends upon value, the metropolitan cities. I mean, presidency towns like Bombay, Delhi, Madras, and Calcutta, where over a particular amount, like 1 crore plus, the original jurisdiction is vested with the high courts. Below that, civil courts. Then, high court also, single judge, division bench, then Supreme Court. Civil courts, civil court, high court, Supreme Court. So, time will decide ultimately. Whoever will be alive by that time, they will ultimately receive the fruits of the litigation. I can't say ADR is a mantra for all, for everything. We had to identify which is the matter to be taken to ADR, which is matter not to be taken to ADR. Some of the criminal matters also now are being taken to Lok Adalats as our Act has been amended, IPC has been amended. Like in 498, a husband and wife relationship. And then 420, DVC. Mostly, these are all the matters. Cheating on 420 also has been referred to now. The Lok Adalats. Lok Adalats. 420 cannot be arbitrated. 420 cannot be conciliated also. But that could be settled through Lok Adalat because we require court stamping for that. Private parties' involvement will create problem unless the matter is settled and the amounts are cleared. Partly paid and partly some amounts are not cleared and 420s, then the problem will be escalated. So only method is, I don't advise even conciliation within my little experience, of course. So before I continue, go ahead with the arbitration and exclusively on that, I'm talking of now courtcraft and methods of ADR. In that, which matter to be referred to which particular mechanism is the question. Sometimes courts will have to decide because under section 89 CPC, all courts can indulge, can decide and send the matters to either arbitration, conciliation, mediation, go for judicial settlement or Lok Adalat, and then, in fact, arbitration, mediation, conciliation, Lok Adalat, judicial settlement. So all courts, in fact, there is no bar. NCLT also can do that. Section 89 has got a very wider application under AFCON's decision of Supreme Court. But the question is, which method at what time? So as I was handling, I think in Jaipur, a very interesting matter, Mr. Chawla ji also was referring to. What was the interesting matter? Husband and wife, partners, shareholders, 50-50. I said operation and mismanagement. Holding 50%, what operation and what mismanagement? Because you charge your gun, other side also will charge your gun. Only thing you are husband and wife. So I said you must be having internal problems. So I called the parties. In fact, I held it in camera in my chamber. I said mediation. We'll work out. Please come and sit in my chamber. Then I told that lady, ma'am, what are the other cases you filed against your husband? She said, sir, I filed DVC. I filed 498A. Very good. Then I filed this operation and mismanagement. Very good before me. Then I said, what is that again you are thinking of? I am consulting my lawyers, my lord. Very soon I will come out with appropriate package. Package. Very good. I said, all this is trash. Your company will be ruined and your employees will be on the streets with families. 10 employees out, 10 into 4, at least 40 persons out. The IBC and these things, especially operation mismanagement, IBC, the tribunals have to be very careful in deciding. Some wrong decision will throw out families and families on the streets. After I returned to Hyderabad, I handled a very big case pertaining to this. I challenged the order in the High Court, in fact. At that time, Supreme Court said you can go to High Court also, in some matters, not all. Because I found 300 employees, families suffering. So at this juncture, I said, well, there is a provision of arbitration. In the articles, you can go ahead. Articles does not contain, no problem. You can agree. Give me a memo, I will send you to arbitrator. They said, no, sir. All that I said, I will pass a judicial order. I will put you through mediation. I will appoint some good lawyer as a mediator. I don't send you to Bombay Mediation Center or Delhi or this is Jaipur. So I said, in Jaipur only, you both are living here. Registered office is there. I told them, if you start fighting, then your life also is ruined. Your divorce petition takes another 20 years. Both of you are fit for nothing. And you can't remarry. Your company is ruined. Your personal company is ruined. You can't enjoy life. Where ultimately this will lead to? Finally, they agreed for a mediation. I remember vaguely it happened 3 years back, 4 years, 3.5 years back. No, I vaguely remember. Then subsequently, I referred to mediation and mediation had been successful. And they got this one and ultimately finished. Happy. So, arbitration also is possible in operation mismanagement cases. Not necessary to be mediation. So, friends, before I go further into arbitration, you must understand, we have got a regular courtcraft. Courts. Civil courts, criminal courts, high court, Supreme Court. Finish. As alternative dispute resolution, we can opt for arbitration, totally third-party adjudication, no court intervenes. When court intervenes, I will tell you next half an hour. It is definitely a successful mechanism. Second, conciliation. Directly, agreement will become a decree on your signature as a conciliator. Parties sign. No appeals. Matter is closed. Third is mediation. Now, this is where the law is not there. Except referring to mediation, Section 89 CPC amendment does not speak of what is mediation, how to do it. But Conciliation Arbitration Act tells you, 61 to 81. So, mediation is more developed as a theory, putting into practice. But mediation centers are there. And what mediation centers do, if the present matter is pending in the court, it will be referred to mediation center. Mediators will be appointed by the secretary. And if it's successful, mediator will make out the terms of success and send it back to the court. And the court will pass a compromise decree. Or else that can be referred to Lok Adalat also. Normally that will go back to the originating court and court will pass a consent decree. Sometimes the matters are referred to Lok Adalat also. Single person Lok Adalat is constituted and then secretaries are acting as Lok Adalat and that is also done nowadays in some high courts. My high court has done it. And then that would be finished. No appeal, no further thing, everything is settled and no further grievances. A has to pay B 1 crore. It is agreed to 50 lakhs and 50 lakhs DD is given, matter is closed. And agreement is signed. Lok Adalat stamps or the originating court gives a consent decree. Finish. There won't be any more escalation. That is mediation. Lok Adalat could be directly referred to. I told you. Regular Lok Adalats, permanent Lok Adalats, mega Lok Adalats. So Lok Adalats also, or judicial settlement, out of court settlement, bringing into the learned judges and then court will pass a compromise decree. So these are all the different methods. Which method can be used at what time? For what we can see. Mostly marriage problems and marriage litigation. The matters could be settled through Lok Adalats, but not divorce. The maintenance and such issues can be taken. Alternatively, partition and commercial matters especially can be taken to arbitration. That is there. Our subject matter. Then where specialized courts are there constituted, arbitration is not possible. So whatever matters come in, if they are maintainable, they can end up in Lok Adalat, but not divorce. They can end up in, that is, Legal Service Authority Act tells you what is not, what is not what is. Then finally, the mediation again goes back to the courts of law. Conciliation directly becomes a decree. Now, with this background, the 5 wings or 5 modes of ADR, I will take you back to arbitration. Exclusively, we discuss as to what exactly is arbitration. Arbitration is third-party adjudication. And what is third-party adjudication? Is that a third person in whom the parties repose faith will decide as to on the rights and liabilities of the parties. Prima facie, I will try to scratch to the surface before I go into the depth of the subject matter. In arbitration, the parties have been given absolute freedom under the Act. Not only now, even 1940 Act also, even CPC also, earlier. I gave you history from, in fact, as back as 1781. So, you can choose your judge, both the parties. You can choose your time. You can choose your place. You can fix up the fees. You can put a time limit. And you can dictate the procedure. The parties are absolutely free to choose. Only thing, they must agree. If they have got an agreement for referring their disputes to arbitration, as I told you, permissible under Section 28 of the Indian Contract Act 1872, and then one of the parties does not cooperate and does not agree for any arbitrator suggested by other side, and this side does not agree for any arbitrator suggested by the opposite side, then if there is an arbitration clause in the agreement for referring the disputes, what will happen? You can't approach the civil court because of that arbitration clause. Section 8 of Arbitration and Conciliation Act. Then what do you have to do? The aggrieved can move the court under Section 11, High Court, or the Supreme Court as the case may be, and the At that stage, the High Court or Supreme Court will intervene and appoint an arbitrator of its own choice, notwithstanding the stipulations of qualifications and such things pertaining to the arbitrator. It may consider the agreement, but it need not be bound by the terms of the agreement with regard to the qualifications and then other things. The court can decide who can be the arbitrator, a lawyer, a company secretary, or in fact, retired High Court judge, or a Supreme Court judge, or a technician like an engineer. Anybody can be an arbitrator. Then that is the discretionary power of the courts. So, my dear friends, once the parties agree to have an arbitration clause, it is not restraint of legal proceedings barred under Section 28 ICA, Indian Contract Act, automatically. If you both agree, fine. Otherwise, court will interfere and arbitrator has got to be appointed. Your dispute cannot be resolved without arbitrator. That is the cardinal rule. Then, in arbitration, you can choose your timings. You can choose your procedure, do's and don'ts. Then, I recall my personal experience. I think before I became judicial member of NCLT, I had the opportunity to appear as a lawyer before one learned justice, retired justice, unfortunately passed away. A very heavy matter. And then we have chosen him and we told him, both the lawyers and parties, sir, keep it on Saturdays and Sundays. That would be convenient for us because the High Court won't be there. And well, we are regular practitioners before High Court, or else in the evenings, but preferably Saturdays, Sundays. Mostly arbitrations take place on Saturdays and Sundays, mostly. In fact, that is because the senior lawyers or even junior lawyers basically will have to be in the courts from morning to evening in whatever court it is. And in the evening, again, they will have to attend to the clients and office. Normally, it would be 11, 12 also. To my knowledge, no lawyer sleeps before 12 o'clock. And anybody sleeps at 9 o'clock or 10 o'clock, he will feel jealous, even me. Never in my lifetime I slept at 9 o'clock or 10 o'clock. Always it is between 12:31 and get up by 6. Then move up. 9:30 we are off from the house because we had to reach the court. Saturdays, Sundays, normally arbitration or like these programs. So body and mind attuned to work. So what happens? This learned justice completed the session and said, I am likely to leave for states. So, Dr. Mohan, will you cooperate? Tomorrow I will dictate the judgment. Can you? The following day happened to be Monday or so. The very busiest day in the courts because Saturday, Sunday holidays. I said, fine, sir. We'll come. Straight from the court I went. Then at 5:30 he started dictating. Of course, I got a lovely award running into 60 lakhs. And then he concluded, his lordship concluded the final dictation at 1 o'clock in the night. He only provided us some night, refreshments, etc., so that it was out of time for food. Supper, virtually. He supplied all that. In courts, we can't do that. No judge will supply us, nor we supply to them. About 8 members were there, both sides, and other lawyers. Finally, at about 1:30, I left the house And that was high-tech city of Hyderabad. At 2 o'clock, there was traffic jam. High-tech city, no? And I reached home at 3:30. Then that's what I'm telling, the advantage, because this gentleman, suppose held up for 6 months, my program, my arbitration would be delayed. My adjudication. Suppose in the court, I concluded arguments, the learned justice went on leave. Until he comes, judgment won't come. In one case, for 3 months, judgment could not be given. And 4th month, it was transferred. And now I had to start up my arguments in the court from square one. See, my difficulty. Sometimes the learned judge is transferred, retired, passed away. Lot of problems we come across. So time is as precious as life. This is my understanding. Time is as precious as life. And when I was a young student of company secretary course during my 21, 22 years, some of the senior presidents and all came. Hyderabad chapter called even us. That is the greatness of ICSA family. President is coming, all you youngsters come. They sent us notices. The Hyderabad chapter of company secretaries. It was there in Little Flower School of Hyderabad in those days. I also went because I was the young student of company secretaries, and president interacted with us. And some president was asking something. One of my fellow students said, I don't have time, sir. Immediately, president, they don't say that. You are a company secretary. Only busy person will find time. What a beautiful. Only busy person will find time. That vibrated and reverberated in my mind, my dear friends. So, if we don't want, we say, I don't have time. If alternatively, we can find out. We can find out. We are serious on the subject matter, we had to find out. Banuji called me other day and said on Friday, I said, Friday, ma'am, it is a court time, I can't come. But any other time. She said, Saturday. Actually, I got some arbitrations to attend from 2 o'clock today. Appointments are there. Then she said, sir, I will close it latest before 1 o'clock, including questions and answers, if you can give your time. I said, immediately, yes, go ahead. Lot of work, I finished it before 10:30 and logged in at 11. Because of the reverberating words of our former presidents, the gentleman, I don't know who was, what is his name, Saxena ji or so, I believe, at that point of time, or in fact, Mr. G.S. Rao or somebody, doctorate.
Dr. G.B. Rao, sir. Dr. G.B. Rao.
Dr. G.B. Rao ji. I think even now it vibrates. Only a busy man will find time. We can organize our time. So what happened? This arbitration process, whole thing completed before this learned judge in 3 months and got the award also, maybe at 1:30 in the night, no problem. In courts, I can't do that. Then I went to home. My wife opened the door and said, I see, kya ho raha? And I replied, night arbitration, this is called. A new coin. I said, arbitration, day mein bhi chalte, raat mein bhi chalte, kabhi bhi, I said 24/7, ye chalte rehte. She was my fortune that she was my wife, and she very cooperatively understood. And then she said, theek hai bhai, aap jao, so jao pehle, baad mein baat karenge. Subah uth ke baad, come on, go, good night. So, this is and you know what happened? This learned justice went to states 3 days later. I got the certificate copy. Then I got EP, etc. and went on and recovered our money. that learned justice was held up in US for 6 months. On return, he fell sick. And within less than a month time, he passed away. Imagine. There are several matters. Hours together, I argued in the courts of law, morning to evening. And subsequently, the subject was changed and the learned justice put it before other court, or learned justice retired, or transferred, or promoted to Supreme Court. And I had to again start up. As many as about 10, 15 cases are now, I think I remember more, minimum 10 cases are there on my file. I had to again start off from again morning to evening, several days. I had to go on repeating the cassette. Of course, clients won't pay additional fees. We can't ask also. See, cost effectiveness, we have got to be reasonable. At sometimes we had to suffer, we had to face it. A lot of efforts put. Arguing for 3 days continuously every day 4 hours is not a joke. So what happens, dear friends, this is the advantage. You can choose your judge, you can choose your timings, and you can cooperate, he will cooperate, and this type of coordination will make out quick justice. You can say at a effective cost price. Today, from receiving pleadings, arbitrator has to render award in 6 months. And arbitrators from entering into reference cannot extend the time for receiving claim statement and other pleadings more than 6 months. And section 29A, what it says, if you don't follow this, then 6 months could be extended by parties with mutual consent. Otherwise, it should be taken to court. And even 6 months later, you didn't do that. Then you had to necessarily go to court of law for extension. And the court can decide giving a direction to arbitrator to refund the fees or cut the fees or even removing him, substituting him. Imagine. That means this is called carrot and stick policy. You act well, do well, and then efficiently work out and follow the timeline. Timeline is very important. There is timeline in IBC. In the same way, there is a timeline in arbitration. The timeline has to be strictly followed now, failing which the arbitrators will be thrown out. So you need not worry. Arbitrators are private persons and they can do and undo things. It is better that we go to courtcraft. You need not think in that way. So in the first phase, what is arbitration? I told you. In the second phase, the freedom of parties. It is by agreement. Section 7 of Arbitration and Conciliation Act. And by agreement, you can do and undo. Choose. What is the freedom you have got, I have told you. And how I was saved and got a decree running even up to 1 o'clock in the night. No problem. Every time it won't happen. That kind of, what I am trying to focus is that kind of accessibility, leverage, freedom available in arbitration, which is not possible to be dictated in courts of law. Of course, once the matter continues, normally today because of the piling up of cases, including High Court and other Supreme Court also sometimes may sit beyond 4:30, but not always. Second thing, the kind of freedom in arbitration we have, we don't have anywhere. There is a provision in Sri Rama's time. Anybody suffers, they used to ring the bell called Dharma Ganta. Is it not? At any time. And then immediately one Doot comes, then reports to Sri Rama. Sri Rama used to get up and come and say, what happened? What is the matter? Most of you might be knowing or may not be knowing that system is prevailing in all courts even today, which is called house motion. If there is really urgency, that kind of problem is available. Arrest, illegal detention, threat to life. Basically, in high courts, there is a provision, Supreme Court also. At any time, 24/7, including holidays, there is a separate cell in my high court also. I myself invoked it some time back. Even night you can go, 12 o'clock. Tell the gatekeeper, we are here with this, I am the lawyer, this is my ID card. Finish. You will go to the officer. That officer will be there throughout night duty. And he opens and he calls the Chief Justice at 12 o'clock in the night. And Chief Justice then will call some of the Pune judges, or himself will hear. He has got that power. Then typists will be called and we'll pick them up, go to the residence of the judge or Chief Justice. If he feels, he will issue immediate orders. And an order copy also will be given on the spot. Duly signed. This provision, most of the people don't know. That is Rama's Ganta, Dharma Ganta is prevailing even today in India. I don't know in our foreign countries. Whereas, but it has got its own restrictions. It has got its own permutations and combinations. In arbitration, it is absolutely your party's freedom and arbitrator's consent. It can be done. But consent of all the three parties, A, B, and arbitrator. So this is the best example what I have given to you, that I saved my 60 lakh award by waiting up to 1:30 in the night. Now you may put a question to me. Arbitration is adjudication, then courtcraft also involves adjudication. In that event, what are the fundamental distinctions between arbitration and conciliation? I mean, arbitration and courtcraft. If you start speaking about arbitration, whole day is not enough. I had to tell you the peripheral area, scratch through surface. This is a webinar series. So I am introducing arbitration to you. I hope my fellow members will understand it. So I have told you what it is, how you can go into that, how it can be surfaced by agreement. Restriction 28 ICA does not apply. That is the epicenter. An Arbitration Conciliation Act has come. The first ADR mechanism is introduced through arbitration in 1781. And then what are the points of distinction between arbitration and courtcraft? Number one, arbitration is informal, courtcraft is very formal. That is restricted with timings. Here it is not restricted with timings. And freedom of parties, second. You can choose a professional. It's a share issue, share market, share issues. Today, I am also one of the panel arbitrators of this commodities exchange. Last year, I got the appointment. They empanel several company secretaries also. Now, SEBI, I think, is coming up now. Mr. Chawla ji has told. So what happens? Share matters, shares, arbitrate panel. In stock exchanges, there is appellate board also. Appellate arbitration also. That is also accepted by Supreme Court, in fact. Only then Section 34. So, company secretaries are the best persons to resolve the disputes pertaining to share market. Shares, debentures, securities. I can put it in another way. because they're experts in that. They're trained. Corporate laws, expertise flows from ICSI. That is the reason why we have got our own branches of IBC, and then we have got our own branches of, I think, valuation also, no? Valuators also, I think, Chawlaji. I remember that because we lawyers don't require it. But company secretaries in practice require it. So our concept is different, practice orientation. Then that is the advantage, specialization. Now the third most important aspect, arbitration. Suppose an award is rendered in international commercial arbitration in India. The award is executable globally in the foreign country also. Whereas an Indian court decision is not binding in a foreign country. A foreigner and an Indian got into a commercial dispute adjudicated by a civil court in India, granted a decree of 100 crores. It is executable within India but not outside India. Take it for granted. An Indian and an American got into a dispute in the New York court. The New York civil court passed a decree in favor of the Indian. The Indian there can go for execution and recovery within that particular country, but he cannot go out of that country. But if it is international commercial arbitration, an arbitral award is passed in US, it is executable under Part 2 of the Arbitration Conciliation Act in India. And vice versa. It is challengeable, of course, in US, but executable in India. And in a execution portion in India, challenge procedure also is permissible under Part. That is a specialty of Part. Only thing, you have to follow Geneva Convention or New York Convention. You see the beauty of that? CPC itself puts a moratorium, restriction with regard to entertaining foreign judgments. So suppose that guy is having properties in India, but I got an order of New York court. What I have to do? I have to come back to India, put that as evidence, put a suit, go for trial, take this decree again here as one of the exhibits, then get a decree in India by Indian court, then attach his properties in India. That is the system in courtcraft. But in arbitration, it's not necessary. So, this is the best advantage of arbitration, especially in international commercial disputes. International law is twofold. Private international law and then public international law. Public international law connects with nations. India, Pakistan, India, UK, India, Japan, at government level. Disputes among nations. International private law pertains to disputes and issues among different nationals. Different nationals, different national entities, a corporate in India, a corporate in US, private international law. India and US, public international law. Arbitration comes under private international law. And the disputes here, anybody is outside India, and even an NRI habitually residing outside India, the arbitration is called international commercial arbitration. So the arbitration has two parts. One is domestic arbitration, and the other one is international commercial arbitration. Domestic is among the natives. International commercial is between different nationals or persons habitually residing in foreign countries or foreign governments also, or foreign entities. So this is the beauty of the subject matter. As we go further, we will enjoy in analyzing the subject matter and coming to conclusions. Arbitrator's task in international commercial arbitration is very tough. I think once I had an opportunity to deal with a matter arising in Finland. It is between Finland, a company in Bangalore, a company in Hyderabad, Trishul. And it went on a different analysis. Finally, I found it is purely a dispute between Bangalore and Hyderabad fellows. Finland already is out. So it is not international commercial arbitration. It is domestic arbitration. Then the arbitration continued between Bangalore and Hyderabad companies. Finally, the matter was closed with an award. So I hope now, friends, you realize the arbitration advantages and the pros and cons and the types, domestic and international. Now, how to conduct arbitration, the procedures, how to write award, how to write judgment is given in CPC. How to write judgment is given in CPC itself. And then, in fact, how to write awards is also given very clearly in the Arbitration and Conciliation Act itself. In fact, it is not that out of hand, for example, Section 33, read with Order 20, Rule 1 to 20 speaks about judgments. Section 31 deals with arbitration award writing 30 to 33. So, clearly, provisions have been made as to how to conduct proceedings, what are do's and don'ts, and what are the subjects to be covered, and how to write your award and how to present it. Against the awards, a challenge procedure under limited grounds given under 34, appeal under 37 to High Court, no appeal to Supreme Court, so that the hierarchy is restricted and interventions of courts also is restricted. Now, interim directions can be granted and executable under Section 17. Arbitrators can do that. So, approaching court does not arise if arbitration continues. Once arbitration takes place, arbitrator can give any interim order. Prior to reference, you can go under Section 9 to the courts of law for seeking any interim relief prior to arbitration. Lastly, what are the matters to be referred to arbitration and what is not? What are arbitrable, what is not arbitrable? Section 2, subsection 3. If there is any specific forum meant for a particular subject matter to be dealt with under law, that subject is not arbitrable. Example, family courts, divorce, or if arbitration is permitted for divorce, then every third family in India will have divorce. That is an unfortunate situation because family courts are flooded with divorce matters today. That is the reason why divorce is prohibited even by Lok Adalat. So divorce is not permissible. But Companies Act, the appointment of directors, operation and mismanagement, the reliefs which a court can give cannot be taken up by arbitration. Then what is permissible in arbitration in operation and mismanagement? Valuation of shares and the disputes with regard to share purchase agreements. No problem. But you want to oust the management and want to replace it by the order of the courts under 241, read with 242, 243, then definitely arbitration is not permissible. Winding up, arbitration is not permissible. IBC, arbitration is not permissible. Mediation is permissible. That is the reason why Hyderabad the NCLT referred some of the matters to the International Arbitration and Mediation Center, started in some time back in Hyderabad, 2 years back. The reason is that mediation, again, it will have to come back to the court for compromise decree in terms of mediation. But arbitration is concerned, no. So you have to see Admiralty matters, Army, service, some of the government service matters where CAT is there, separate fora established, arbitration is not permissible. Then what are the matters for arbitration? All commercial matters. Take it for granted. Arising out of agreement or even non-agreement. What are they? IPR, copyright, patent, violation. That's why WIPO is there. World Intellectual Property Organization has come. All these matters could be taken for arbitration. Then partition matters also can be subject to arbitration. But not other family disputes. Granting of restitution of conjugal rights, divorce, judicial separation, maintenance, custody of children, arbitrators cannot interfere. So take it for granted all commercial matters. We company secretaries deal with only commercial matters. So obviously commercial matters. Second one, the partition matters or any commercial matter, international commercial arbitration. That would be taken up for arbitration, either domestic or international commercial arbitration. So friends, these are all the basics of arbitration. In fact, each item we take in a further phased way and then start off at every stage of conducting starting from section 17 interim directions to ending up correction of arbitration awards, mistakes, etc. 33, read with 34, challenge, 37, appeal. All these things could be dealt with. I think 2 days not sufficient. So not necessary. In fact, this particular thing is first webinar. I thought I can't dump everything on you. So first I had to sensitize the issue and I had to give you the basics. So with that, let us see any questions and answers. Then we can conclude. Any questions and answers, sir?
Yes, sir. There are many questions asked. In fact,
mostly they might have been answered in course of my lecture.
Correct, sir. That's what I was about to say, that there are many questions asked. 38 I have already received in the group. And there are some questions they have already made and list is long. And many questions you have already answered. In fact, the number of participants are huge. 15,000 participants at the moment are currently attending the... so that's your fan following, sir. That's how people are glued to their systems, getting the knowledge directly from you. And on a Saturday, instead of enjoying the weekend, they thought to enjoy the weekend by learning. And there are some basic questions, sir.
We can go on.
Yeah, so I'll ask questions quickly and you can briefly answer them because otherwise you have covered, but still people would feel motivated if I ask their questions. So
I'm really blessed. 15,000 participants. My pranams.
15,000. Yes, sir, absolutely. Sir, one question which 3-4 people have asked, is there, because this question is very simple, although I also mentioned it and you also explained it, but still at the cost of repetition, we must clarify. Can any professional be appointed as arbitrator? Is any empanelment to any portal is mandatory to be an arbitrator?
See, any professional, any person of age of majority can be appointed as an arbitrator categorically, subject to the disqualifications and qualifications as rendered under the statute, where the arbitrator should not be connected as a relative, number one. The arbitrator should not be a counsel, and there should be a moratorium of 3 years expired. Like that, there are certain restrictions. So, for example, in one company, I worked as a lawyer, and then later on, my job is over as a lawyer with that company. And that company comes to me to act as an arbitrator. I think 3 years' time is given. That expiry of that, I cannot. So, because I was the advocate of that particular company. So suppose a person is the auditor of X company, that auditor cannot be the arbitrator of X company for that if he continues. Even after that, there is a cooling period. So these things we had to see, and we had to give a declaration also. under the statute, there is a schedule given. Under that, we had to give a declaration. We are not connected and we are in able position to do this. We can discharge. Compulsorily, we had to give a declaration, whether asked or not. And we ourselves will have to ensure from the clients that they are whether way, anyway, in other way connected also. If so, then if it is a remote connection, fine. But if it is a direct connection, then you have to recluse. You cannot act as an arbitrator. These are all the things we have to take care of.
Correct, sir. Just to supplement you, I think there was a specific amendment which was made in the schedule. Even company secretary, chartered accountants were included, but then the government has again modified that schedule. And now there is no qualification. Otherwise, in between now, a couple of years back, we were very happy that we were included in that specifically made list. But that has again been changed and now the ground is again open for anybody to be the...
Sir, actually, may I add up,
Yes.
Shabnaji?
Yes, sir.
Company secretaries, advocates, chartered accountants, for example, cost accountants, are the best for engineers, retired judges, are the best persons for arbitration because they are connected with law, accounts, basically. It all depends upon the subject. Suppose it is an irrigation project and connected with a lawyer and a retired judge or engineer, and then a cost chartered accountant would be the best combination. Shares, some of the operational mismanagement or regular commercial disputes, company secretaries are framing agreements. So in commercial disputes, advocates and company secretaries combination will take us to very long way ahead and we'll be the best persons. And one thing I want to tell all of our members for the pride of our institute, the Hyderabad ICSI COE Center first time started after I returned from NCLT. In fact, gave me an opportunity to start off also. I am grateful. In December 2019, first arbitration rigorous training program. And it had become a great success. But now we have trained over more than, I think, 400 or 500 people. The center as arbitrators and live arbitration cases have been given and they were put on 3-day rigorous session and 3 days preliminary session, total 6-day session. And they were all given certificates. And then best arbitrator also was elected from the performance. So only our institute at All India level started the arbitration training program. So I can say our institute has the pride of producing trained arbitrators. Put it in this way.
Great. That's a great motivation. I'm sure people who are members who are serious will attend these programs, will go there. It's a residential program. We have got a beautiful campus.
We have got advanced program announced already in the month of August. Then that would be somewhere on, I think, 11, 12, 13 or 18, 19, 20. You may get in touch with COE Hyderabad Center. 3 days advanced training program. And then 30 seats only are there. And that would be again a rigorous training program. That would be the follow-up of basic program, which was already done. We always take 3 days basic program with a gap, advanced program. Before that, a orientation program. So this is the methodology we are following. Very scientifically, it is successful. It's done and successful. So I think all the members can now contact the COE Hyderabad Center. Now it is CGRT or so. The name is CCGRT. And get in touch now. They have already circulated flyer also.
Correct, sir. I got to know
about advantage of training.
Correct, sir. I got to know about this from my council colleague, Mr. Venkat Ramanna, who is chairing this Hyderabad initiatives and CCGRT Hyderabad. Mr. Venkat Ramanna
only as chairman approved this flyer and then he released it.
Correct. We discussed this in our council meeting. Sir, there is an interesting question on which I recently read a judgment. Can a supplier of goods pursuant to a contract with an arbitration clause seek recourse in MSME Act without invoking arbitration if the supplier is MSME enterprise?
Very good question. Very good question. If there is no arbitration clause in the agreement, as an MSME, he can directly go to the MSME council And MSME Council will constitute arbitral tribunal. It is already permanently made out all over India, in all states, and he can make a complaint. But now the dispute is, if there is an arbitration clause and arbitration has been triggered either under Section 11 or so, then MSME cannot be approached. So now MSME concept, what they're saying, even arbitration clause is there. If one of the parties approaches MSME, since that clause is not invoked or clause is not there, the MSME Council can act as an arbitrator.
Correct, sir. This judgment which I am mentioning, this is a very recent judgment which I had read somewhere and then I was trying to find out. Yeah, it's there. This is Gujarat High Court. And this says court cannot appoint arbitrator under Section 11 when the dispute is covered under MSME Act. Gujarat High Court reiterates, and this says the citation also I'm trying to look at.
Yeah.
So this is an interesting aspect because there is this MSME is our own act again. You know, many of our members are. This is Samrat Furnaces versus State of Gujarat, SCA 7006 of 2020.
Chawla ji, may I add a permit me?
Yes, sir. Please, sir. Not
this
permit,
is
sir.
called persuasive precedent over India. This is restricted to Gujarat state, but not other places.
Absolutely.
Very quickly, I will share in half minute my experience. I am a counsel for BSNL, and in BSNL there is an arbitration clause, and the arbitrator at that point of time, before 2015 amendment, happened to be appointed by BSNL. And the opposite side supplier went to MSME Hyderabad because jurisdiction was here. I argued before MSME, you cannot exercise jurisdiction. Then the MSME said, no, we will go ahead. Then we approached the division bench of Telangana High Court. Now, at that time, AP High Court. High Court immediately stayed all proceedings. So this is contrast to what happened in Gujarat.
Correct, sir. Actually, it's, in my view, it's an option.
Yes.
It's an option. If MSME is not invoked, then if there is an arbitration clause, one of the parties have invoked arbitration, then certainly Section 8 will apply, and then they'll have to go for arbitration because ultimately objective is to achieve an alternate dispute resolution, and they agreed specifically to have the dispute resolved through
Section 11 will have to be invoked.
Correct. Then 11 will have to be invoked. Correct, sir. So
alternatively, you don't invoke anything, then you can straight go for MSME Council.
Correct, sir. So there is another question which they have asked. In relation to drafting of an arbitration clause, when there are two parties based out of two different countries, what is the most suitable and cost-effective arbitration place and manner that we should mention?
It all depends upon the subject matter and parties' wish and will, no? Because it is on the agreement of both the parties. So both the parties will have to agree. Suppose it is between UK and India, and the place which law will apply, Section 28 of Arbitration and Conciliation Act. And parties will have to specifically say what is the seat. Now, seat of arbitration is very important with regard to Balco's case. Balco's case is our guiding factor. So my opinion is that what is the best means, how the parties agree and where we have to ultimately agree and then going to for drafting is the question. That is the reason why we can't put a hard and fast rule, according to me.
Correct, sir. Sir, there are many questions which our participants have asked with regard to MSME and the interplay of the Arbitration Act. So what has come to my mind, being the moderator of this first session itself, we'll request Banu ma'am and the team ICSI to formulate participants. We can do one thing, that we'll formulate a special session on interplay of MSME and Arbitration Act and share the difference in the procedure. What are the judgments dealing with this subject? What are the judgments? What is the view of different high courts? What are the Supreme Court view on it? We'll have a separate specific session because our members are already working in MSME and there seems to be a confusion with regard to this and many questions have been asked for this. So we'll have a separate webinar of 2 hours only on interplay of MSME and Arbitration Act.
Because you cannot call panelists for that.
Correct, sir. We'll have.
And one more thing, MSME concept in IBC now is very much
Correct.
rampant in NCLT.
Correct, sir. It's there because of 29A. Because the exemption is given from the 29A being the bar not being there for MSME. I share my case. There's a case from Hyderabad. They admitted the company to CIRP. We challenged. We are before NCLT Hyderabad. We are before NCLT Chennai. But in the meantime, being MSME, we are also, because there is no stay given by the court. So we are also putting our plan, being the promoter and eligible, being the MSME.
Yes, exactly.
So there are few questions which many participants have asked. I feel, considering the time also, with regard to the drafting, how to draft the clause to ensure that there is no dispute with regard to the clause itself. Now, my experience tells me, and I need your guidance on this, I have seen the first issue in every matter. I am doing this high-stake arbitration in relation to 2 years, went only in one line that first agreement would be covered, but there is still overlapping. The language was loosely drafted because somebody else drafted it. So I think for drafting of an arbitration clause, also participants and members, we would request that we'll have a separate webinar on drafting of the arbitration clause and what is the most appropriate clause, the seat, place, venue, the issues, the judgments pertaining to this, and the drafting of the clause. Sir, any tips by you? How can please, sir?
One piece of tip I may be permitted.
Please, sir, please.
Let us make the clause as simple as possible and leave it to the application of Arbitration and Conciliation Act provisions. So that what happens is the Act will operate. If we start putting 3 pages arbitration clause, it will complicate the issue and the arbitrator also will be bound by that he is helpless. Then later on parties fighting won't amend it. It will create a chaos. So my opinion is that as some of the clauses with my little knowledge I have seen, it should not be too elaborative. The seat of arbitration must be number 1. The subjects of arbitration, if it is pertaining to that particular agreement, and don't make reference to any other previous agreement. Some of the mistakes are done in that fashion. Third point, within that, whether it is sole or a panel also must be made clear. Always, my experience is better to it be sole. It is cost effective and less complicated. If it is a panel, even 100 crores, 1,000 crores, you can choose a person having that kind of brilliance rather than putting 3 people or 5 people. This will complicate things because people start pulling different ways. And cost is also high. Please see Schedule 4. The payment of fees concept is different for panel. So that kind of situation we avoid. But in foreign countries also, international commercial arbitration, there are sole arbitrators. It is not that only panel of 3 should be there. So this is also support. Otherwise, what happens? I appoint one, opposite side does not appoint one. I had that problem. I filed as many as about 120 cases in Telangana High Court, sir, under Section 11.
Oh, really? Oh.
Section 11. It is on record. Because I appointed my arbitrator, opposite side does not appoint. I had to seek that appointment. Then both of them should appoint presiding arbitrator.
Correct.
So this is the advice I think we can give to our members with our my little experience of.
One question which you have already answered, but for clarity, I am just mentioning the question and what you answered. Sir, what happens when there is a dispute in appointing the sole arbitrator, whether the arbitration clause loses its significance? No, then we'll have to go to Section 11. Is what
absolutely right. Section 11.
Then we have to go to. Sir, if an arbitration is mentioned in if an arbitrator is appointed by the High Court, can he act as the conciliator?
See, he cannot reduce it as a conciliation settlement agreement and act as a conciliator, but he can invoke Section 30. He himself should not indulge with the parties. He can allow them to come along themselves and then settle. And if finally they reach 95% settlement, 5% he can be a little bit suggestive and make out a Section 30, in fact, award. Otherwise, he can appoint a mediator. Once he appoints a conciliator, he is out of picture. Because conciliation settlement agreement directly becomes a decree. So he can use the methodology, but he cannot call it conciliation settlement agreement. This is my opinion. And I have done this recently with a learned High Court justice also. And then, in fact, we ended it up on section 30, but mediatory process we used. And then finally, we came to conclusion and give a settlement, and it was done. And two big giants, I acted as an arbitrator. I asked them to settle it. They came with 95% settlement, but 5% they are fighting. I was the arbitrator. It was 20 crore matter. So I suggested them, can you do this, but without myself indulging? They said, yes, sir, we follow you. Then they said, reduce it into writing. Then I rendered a section 30 consent award. Matter was closed.
Great. That's how we find solutions, sir. That's what we learned from your practical insight.
My little knowledge.
In NCLT bench, one of the participants are asking, I know time is short and you have to go for arbitration at 2, so I'm just finishing. In the NCLT bench, Delhi moved an application for mediation. There is no mediation center.
Anybody as a mediator. The principal bench of NCLT Delhi very recently appointed me as a mediator, and I concluded the mediation sessions and ultimately reported what is the outcome. So anybody can be appointed, not necessary to be on the panel. Mediator panels can be maintained. There is no bar. Even not maintained, anybody can be drawn, anyone can be appointed. If it is Delhi NCLAT, it can be referred to Delhi Mediation Center also.
Correct, sir. Delhi High Court Mediation Center. That's what I was mentioning.
Yeah.
Madhyam. It's called Madhyam, and that's a very, very well working.
Yes, we can guide the NCLAT bench to refer it to Delhi bench, High Court Mediation Center, or appoint any lawyer, senior lawyer as a mediator with reasonable fees fixed up.
Correct, sir. I think I'll take this as the last question now. Or maybe the second last question, that we are NBFC company, the participant is asking, sir. And in our loan agreement, we have Mumbai as place of arbitration. Our borrowers are based in Telangana and AP. In such cases, we initiate arbitration in Mumbai. We give notice for 3 hearings with a gap of 30 to 45 days after the notice. Nobody appears. And ultimately, an ex parte order is passed.
2015 amendment later, arbitrators solely cannot be appointed unilaterally. Both the parties must appoint. So because it is one-sided appointment, that cannot be, in fact, sustainable. If both the parties don't agree, one party does not agree, you have only option to go to High Court and then file an application under 11 and get appointment. So that particular award also will go normally. Better we don't take that risk.
I agree, sir. Sir, what if there is mention of commercial court as dispute resolution in contract, still parties can invoke for arbitration? If yes, do they need to amend the contract?
See, in commercial court, the agreement itself contains arbitration. Commercial court matter. Question of going to commercial court does not arise. Section 8 will come.
So if there is no agreement in the commercial contract,
then what happens is, very good question. I will answer. I am happy to receive such questions, dear friend. First point, before approaching commercial court, you have to get certificate from mediation center, mediation failed. Second point, after the proceedings, mediation fails and proceedings start in commercial court, Section 89 has to be invoked automatically by the learned justice, not by invocation of parties. Under 89, court will ask you, and you can opt for arbitration, it will be out.
Correct. So one, in fact, practical question, practical situation I recently faced, obviously with regard to Section 917, that you can explain because somebody is asking whether interim award can be passed. Interim award can also be passed.
I clarified. I already clarified. Section 17 now amended. What is there in 9 also is there in 17, but arbitration starts. If before starting arbitration, 9. After starting arbitration,
Correct.
17.
Correct. So many times, even High Court is saying that, no, sorry, we are not granting any relief in 9. You go to the arbitrator in 17. Most of the times they are doing, unless it is really urgent and we are able to make out a pound with regard to the 3 prima facie case, balance of convenience and irreparable injury.
Yeah.
I think, sir, we have covered most of the questions. There are some questions which are repetitive, and otherwise also this is a series. The other questions which are left, we will be covering in the next sessions also. That's all. I think we would thank our participants, but more than that, sir, we would thank you, despite being a Saturday, being so busy. I'm sure you will continue to bless your own alma mater, your own institute, all of us. And whenever I am going to come next to Hyderabad, which I keep coming as appearing in Hyderabad also, some matters, would personally come and take your blessings also, sir.
I'm grateful to one and all for patient hearing in 15,000 base. Really, I'm grateful, and then thank you.
At the moment, it is 15,331 participants. It is increasing. If it was not your arbitration, generally the trend is other way around.
Yes.
Generally, when we start, it is higher. By the end, it will go down. So it is the reverse in your case. And the climax is coming and people are coming to see the climax.
Sir, my intention is only this. The first arbitration training deeply was started by our ICSI, and let our flag flies very high.
So nice of you, sir. So proud of you.
All the best to one and all.
Thank you, sir. Thank you. Thank you, all the participants. We continue to see you in our later events. Thank you, sir. Thanks, sir.
Namaskar. I will leave. Thank you.